Well, good morning, everybody. Very great pleasure to be here. Now, I've called this short talk, The Legal Profession, Its Three Most Pressing Issues for 2022. And I should start by making it clear that I'm necessarily giving a personal opinion. And I can't deny that others might identify three different most pressing issues without in any way being wrong. But in summary, I'd identify those three pressing issues affecting the legal profession as follows. First, its approach to diversity. I'm concerned that within the legal sector, women and people from different backgrounds are not always made to feel comfortable and included in their working environment. And secondly, I'm concerned about a connected issue, namely the legal sector's ambivalence, or at least somewhat contradictory approach to the adoption of new technologies. The issues are connected because adopting new technologies can and will improve diversity in the legal sector in ways that are not at the moment properly understood. And the third issue that I believe is most pressing is also connected. It's the need to find ways in which lawyers can add value and therefore be properly and appropriately remunerated for work in the brave new world of 2022, without so often following the business practices and methods of the 20th century. And this is connected also to the issue of diversity and technology, again, in ways that are not fully grasped. So, are women and those from diverse backgrounds made comfortable and included in the workplace? Now, for some years, I was chair of the Social Mobility Foundation, a charity giving talented young people from less privileged backgrounds the opportunity to enter professions. And the problem of social mobility, like equality, diversity, and inclusion, has proved stubbornly resistant to change across professional life in England and Wales. And that's down in some part, if not in large measure, in the legal sector at least, to the problem of inclusion, or perhaps more specifically, exclusion. The failure to provide an inclusive working environment is not normally deliberate. Of course, there are rare cases where women or minority ethnic lawyers or lawyers from less privileged backgrounds are deliberately excluded. But a more pervasive problem, anyway in my opinion, is accidental or unthinking exclusion. Lawyers, perhaps, tend to be more upfront than members of some other professions. Perhaps take engineers or accountants as examples, but I'm not insulting them. Lawyers tend, and I don't mean to be rude, sometimes to like the sound of their own voices. They sometimes, perhaps often, fail to see themselves as others see them. And this is problematic for inclusion. It's a characteristic that is particularly prevalent in white men, dare I say it, older white men. Women and people from less privileged backgrounds generally have more caring responsibilities, less time to socialize with colleagues. Minority ethnic communities may face other barriers to socializing amongst colleagues. It's therefore all the more important that those otherwise excluded feel included in the social life of their working community and in incidental conversations whilst they are at their place of work. Making an effort to include everyone should be an active choice for us all. And if white male lawyers are regularly talking about subjects that do not interest others, do not interest women or ethnic minority lawyers or those from less privileged backgrounds, they will inevitably feel excluded. And it's difficult to generalize, and it doesn't matter perhaps what topics make particular groups feel excluded. But women are often less interested than men in sport. Talk about elite schools and universities is likely to make those that didn't have the opportunity to attend them uncomfortable. Subtle factors are very important in attracting and particularly retaining diverse lawyers in the profession. I know that it's easier to state the problem than to solve it, but I think that explaining the issue in simple terms to everyone is a particularly this issue to everyone in the peculiarly exclusive profession would do a lot towards improving the position. Many simply do not realize that exclusion is going on, and there's a similar issue in the judiciary, where judges in regional courts and elsewhere often have lunch and take breaks together. If the conversation is exclusively about Oxford, cricket, and the latest operatic production at Covent Garden, it will exclude judges from backgrounds where none of those things is of interest. Now, the issue I've described is obviously not the only diversity problem we face. The incidence of bullying, harassment, and discrimination is less rare than many in the profession may have thought. But I think the microaggressions that are reflective of a lack of inclusive behaviours are something we all need specifically to address. Like so many problems, understanding it is a first step towards a solution. And one positive observation on this first point: the great development I have recently observed in local courts around the country is the phenomenon of the younger and more diverse judges starting to set the agenda in judges' common rooms. And this is a trend that I hopefully will start to snowball. And my plea is for more to be done to train everyone in the legal sector in inclusion and to work towards eliminating the inconsiderate behaviours of yesteryear. If any of us is going to spend 20, 30 or 40 years in a single profession, we want to feel part of the scene. And as I say, there's a real role for diversity training here. Only when I received it 30 years ago now did I realise how crucial it was. It's widely available, but less widely taken up where it's most needed. Let me come to ambivalence to technology. There are probably as many different attitudes and approaches to the use of technology as there are people in this room or in the legal sector. Lawyers are very, very rarely openly dismiss technology. Many quietly hope that they will be able to retire before it affects the way they practice. But even that cohort would not openly dismiss technology. Proper legal Luddites operate only behind closed doors. But instead, lawyers tend to do something more insidious. They find ways to argue that their particular corner of legal practice cannot be improved, streamlined, or heaven forfend, be made more cheaply available to the public or to business by the use of technology. And this is, of course, almost always wrong. Secondly, some, perhaps even most lawyers, accept that technology can assist with repetitive tasks undertaken in probate, in transactional business, in commercial litigation, in personal injury cases, and in every other kind of legal business. But they do not consider or even contemplate that technology is not just about how lawyers dispense legal advice or undertake legal transactions. Technology will affect the very substance of the work they're being called upon to do. Cases will be different in the future, transactions will be different in the future, and lawyers will need to think differently and be trained differently in the future. There are easy generic examples of this. Even now, cases and transactions are complicated by the volume of data available. This is data that would never have been available in bygone times. In crime, there are massive volumes of CCTV footage, texts, and mobile phone metadata produced in so many cases. Likewise, in many family and some personal injury cases, in commercial cases, the volume of material considered for disclosure grows with every new innovation or new communication medium. In almost every kind of case, it will not be feasible or desirable simply to continue expanding the volume of data that needs to be considered before legal decisions can be taken, without fundamentally reconsidering the process upon which we are engaged. I've spent my entire professional career trying to simplify the issues that are required to be decided within the litigation environment. Unfortunately, however, expanding data tends to make those issues more extensive and often less approachable and intelligible to ordinary people. We must therefore use technology to restore the balance. We cannot put the data genie back in the bottle and simply reduce the amount of data that's available. I think every litigation lawyer's primary objectives should be simplicity and intelligibility. We heard it this morning for ourselves. They should regard it as their essential duty to simplify the problem so that it can be easily and quickly digested by the client, by the witnesses, and ultimately by the court. There are also, of course, lawyers that love technology. Some have accused me of that. There are those that embrace every new gadget, widget, or program. Even they are not, however, always doing their clients any favors. Technology is of no value for technology's sake. It's only of value if it makes the legal problems faced by real people and real businesses easier and cheaper to understand and to resolve. I firmly believe that the adoption of new technologies can and will improve equality, diversity, and inclusion in the legal sector. And this first requires an acceptance that technology is here to stay and that the legal sector is not exempt from its ravages. First, the digital justice system that I'm spending so much of my time in creating will be accessible from any location at any time, and decision-making within it will be capable of being asynchronous. Secondly, COVID has accelerated the use of video conferencing technology. It already reduces some costs in delivering legal advice and makes many types of court hearings less costly and more easily accessible. Thirdly, and more generally, working from home became necessarily popular during COVID and is here to stay. Of course, I acknowledge the value, indeed the necessity, of attending the office and of face-to-face court hearings in some types of case for some of the time. But technology allows lawyers to operate remotely. Now, all of these examples show how we will work and will allow people from all walks of life to remain or become lawyers when they might otherwise be unable to do so. Remote, more flexible, more accessible working patterns allow more women, more ethnic minority lawyers, in fact, any and all of those with other demands on their time, to combine this with their professional practice. Lawyers should be the very last people, therefore, to resist the use and adoption of new technologies. They provide the flexibility in working practices that has been lacking in generations past. Perhaps even more importantly, the massive acceleration in the availability and use of data in all parts of our lives, and the ubiquitous use, as it will happen, of distributed ledger technology will revolutionize the kind of work that lawyers will be doing. Once every event in every industry is indelibly recorded on chain, there will be far less room for the kinds of factual dispute that lawyers are accustomed to dealing with. The causes of road traffic accidents could be photographed and recorded on chain and would not need to be determined by judges. Transactional data relating to both businesses and consumers will be permanently available. It'll be the processing of that data that'll be important, not determining what actually happened in the first place. And it's these changes that give rise to the third pressing problem that I'm now going to address. I don't think it is controversial to say that lawyers tend to be rather conservative about their work. If they've once become specialized in a particular area of law, they're keen to preserve their expertise and the flow of instructions within it. But rapidly advancing technology has the tendency to change what clients actually need from their lawyers. And without being indelicate, lawyers are often the last to let go of outdated practices. In my view, at least, the watchword of all legal services should be that they provide a service that clients need, and that the service adds value for the client and is not simply part of a process that technology could quite easily perform without input from trained lawyers. Let's take the example of transactional work undertaken for business clients. lawyers have for many years now been conducting a love affair with Microsoft Word. But Word is not smart in any meaningful sense. Every time a lawyer starts to create a new transactional document using Word, whether it's a share purchase agreement, a conveyancing document, or an employment contract, all they have is a template. It's now perfectly possible to use smart programming to create any kind of transactional documentation electronically by simply filling in the required fields, leaving the basic form to be created by the machine. These systems have massive added advantages over word processing. They give the client and the lawyer access to transactional data relating to everything that the client has done at the click of a mouse. And the second example relates to probate and conveyancing. I've been struck by how little these processes have changed in 50 years since I began in the law. Both conveyancing and probate could benefit from a massive digitization campaign I haven't got time to explain. And my third example relates to personal injury litigation, where the Road Traffic Act and other portals have had a salutary effect on the process. We heard argument in the Court of Appeal last week in the case of Belsner and Cam Legal Services, and that case has shone a spotlight on how technology can assist. Much of the process of making RTA claims through the pre-action online portals could be more streamlined, less costly, if technology were embraced. So digital processes allow for home working, remote working, asynchronous legal activity, and allow diverse lawyers to remain in the profession, notwithstanding burdensome family and caring commitments. Let's hope this lesson will soon be learned. So let me conclude. Equality, diversity, and inclusion, like social mobility, are sometimes regarded as too big problems to do anything about. I don't accept this is so. If we do nothing, nothing will improve. First, we can move towards a digital justice system where much more of the work is done online and can be undertaken from home and at times that better suit the lives of those with other responsibilities. Secondly, we can and must train all lawyers and judges at all levels to understand better the principles of inclusion, of making themselves fully aware of how they are seen by others, and of making people of all kinds and from all backgrounds feel comfortable and on an equal footing in the workplace. There are many more steps we can and should take, but I would sound one word of warning. It's important to take the entire community, in this case of lawyers and judges, with you on the journey. Like so many problems affecting humanity, the solution is education, not shouting. Thank you.
Well, thank you so much for that, Sir Geoffrey. Insightful and interesting, and also interesting to hear him say that lawyers love the sound of their own voices. I can tell you for sure that journalists also love the sound of their own voices, so there's something we have in common there. Before we proceed, I wanted to open the floor to any questions that you may have for Sir Geoffrey. Would anyone like to ask a question? Please put your hand up and we'll... Gentleman at the end.
From the Council for Licensed Conveyancers, we regulate conveyancing and probate practitioners. I was delighted to hear your support for the digitisation of both of those processes. We are doing a lot of work with people across those industries to try to make progress there, but it is like walking through treacle sometimes. What could we do, in your view, to move those conservative lawyers a bit faster down this road to the future? And would you help us with that?
I would love to help you with that. I think all legal services need to be brought into the 21st century. And what I said is not meant to be a criticism of lawyers. It's just a problem that once people are trained, they establish a practice area, they know what they're doing, it's very easy to be complacent and to say, I've done it like this for years, it works, and I'm not charging my clients too much. I don't think I'm charging my clients too much. What the client thinks is never really asked. and then you find that nothing changes. What we need to do is simply promote, and this is what the Law Tech panel, Law Tech UK, that I am a member of, tries to do, is to promote ways in which legal services can be delivered, and indeed dispute resolution can be delivered in a way that is technologically enabled, just as fair, just as just. We're not talking about robo-judges, but is quicker, more efficient, and reaches the solution which everybody wants at a far greater pace and lower cost. And I will support you in that.
Lady at the back.
Penelope Gibbs from Transform Justice. You talked a bit about the judiciary and some of the conversations they may or may not have in their dining rooms. I wondered if we could get a bit further forward, if the judiciary themselves opened the door to academics to look at unconscious bias amongst the judiciary themselves, and what the drivers to that might be, and what interventions and approaches might be most effective in addressing that.
I think you'd be surprised how many doors within the judiciary are open. And the judiciary is listening to all points of view. The judiciary has to maintain its independence. It has to be very careful that we are independent for everybody, and nobody can say we are adopting one angle over another. But academic study, there is a wide range of academic study within the judiciary. We certainly want to deal with areas like unconscious bias, and we are doing so. The question of how those things are done, I'm not going to talk about now, but I am certainly confident that the judiciary is trying to improve in all the areas that I've mentioned, and in many actually that I haven't mentioned. And a lot of work is going on. Again, it's not overnight. You have to bring everybody with you. And the judiciary, like the law, is a conservative profession, and the people are generally of an older age group, and you have to bring them with you, and it takes time, a bit like the conveyancing. You can't just change all the conveyancers overnight and demand they stop doing conveyancing in the way they did it before and do it in another way. It's a transition, it's a progression, it's an improvement, and it's mostly about education.
Lady in the second row over there.
Frances Harrison. I'm speaking as chair of my local citizens' advice in Brighton and Hove, and it's quite interesting parallel situation because, as you probably know, citizens' advice is there for everybody, but everybody can't get in at once. And so you've got to work on the digital side, the website's got to be accessible, all of those different channels. But we still need to provide face-to-face. And I was just wondering what your thoughts were around how to maintain that ability to drop in and have face-to-face and advice alongside that move towards digitalisation, which is so necessary.
Well, I completely agree. We heard it on the clips earlier. It's absolutely critical that some people need, as the lady, one person put it, I needed my hand held. And in your neck of the legal woods, probably more people need their hand held than anything else. And in family work particularly, it's virtually impossible to say it will all be done online because you're dealing with emotional situations. It's all completely different from a commercial situation. We need diversity of legal provision. We need to be able to judge when people can understand and do want to use a technologically enabled dispute resolution process or delivery process for legal advice, and to let them have that. And we need to understand when they can't, and to make sure that they are not digitally disadvantaged. That's absolutely critical. And indeed, the digital justice system that we are creating with HMCTS is exactly like that. It provides for people who can use it a process that is much more streamlined, much more digitally enabled, much quicker. But if you can't use it, you can still get access to it with assistance for whatever disability or whatever inability you may have. And I just think we should not assume that a large proportion of our population don't find themselves very capable of using this machine. And they are surprised when they can get everything except justice on their mobile phone. And actually, we need to deliver justice on the mobile phone because there are hundreds of thousands of small claims that can be dealt with really easily online. The problem, the dispute, is normally some kind of misunderstanding. It's often really not a very difficult dispute that requires judges from the Court of Appeal. It's something that needs ironing out, and often the digital process can do it. So it's horses for courses. We absolutely mustn't exclude the digitally disadvantaged. We absolutely must ensure face-to-face contact where it is appropriate, and it often is, as I say, in family and criminal and some other areas. But we must make sure that there is much better access to justice by using the digital environment where we can and where people want it. And you'd be surprised how many people do. I mean, I'm quite old, as is quite obvious to everybody, but young people, sometimes I talk to judges and they say, oh, it was really difficult. I had to do 10 clicks to get into this. And I say, have you ever watched your son or your grandson or your daughter do 10 clicks? They do 10 clicks in minus no time, right? And so actually, most people want accessibility to technology, and we can deliver it.
Gentleman in the third row over there.
Thank you. My name's Richard Moorhead. I'm a law professor. I spent 5 years teaching a course called The Future of Legal Practice, motivated by many of the enthusiasms and interest in technology that Sir Geoffrey talked about. And the conclusion that I reached towards the end of that is that actually technology wasn't so much the important issue that needed addressing. The issues that needed addressing and lawyers and law students needed educating on were service, understanding service, and understanding good design. And I just encourage those two issues to be really part of any agenda around the implementation of digitisation, technology, and so on. I have become aware recently of research which is coming through on some of the, if you like, on-phone apps that Sir Geoffrey talked about at the end there, and that's starting to show that actually poor design in relation to those apps is what's inhibiting use as much as, if you like, Luddite reactions to technology. So I think it's not just or even mainly about the tech. It's probably more about understanding service and understanding and evaluating design.
Well, you're completely right. And of course, the better the design, the more it costs.
The lady over there.
Hello, I'm Joanna Connolly. I'm chair of the Solicitor Sole Practitioners Group. In my practice, I'm a solicitor advocate and I practice consumer credit law. You mentioned there were thousands of claims that could be dealt with very easily online through the new processes. I defend people who are being sued by creditors, and the Consumer Credit Act itself is a very complicated area of law. How are you going to ensure that they have the right advice on that? At the moment, you run pilots being run in the county courts, certain county courts, whereby there's no trial for claims under 10,000. And it's going to be determined on written submissions. How is a consumer who is a litigant in person, not well versed in drafting submissions, up against a creditor who has their own legal department, their own lawyers, barristers, going to be dealt with fairly when they no longer have the right to a hearing before a judge who does know the law?
No, they will have a right to a hearing. They will have to ask for it in some cases where the judge thinks it is a case suitable, a small case suitable to be determined in writing. But if the consumer doesn't understand what's going on and asks for a hearing, they will get one. And that is obviously a protection that is required in every such case you're talking about. But I think you have to be careful not to extrapolate from the hard case to every case. There are lots of cases which are not hard cases, which can be determined more speedily. There are literally millions of cases that go, small claims and Road Traffic Act claims and tribunal claims that go through the system every year, millions of those claims. And we need to find a way of dealing with the ones that don't attract the difficult points that you're talking about, speedily and at low cost, leaving the courts free to deal with the difficult cases and to give time and face-to-face hearings and to explain to the clients what's going on, explain to the parties what's going on and why the decision is taken.
In the pilot schemes that's being run, on the direction questionnaire, it's not it just says to tick the box if you want it to be dealt with on paper, whatever it is. There's a new box being put in. But what it should do is say, is this a Consumer Credit Act claim? If it was a recovery of goods, they have to use the Consumer Credit Act procedure because they have to have issued the default notice, they have to prove it to the court. Money claims are exempt from the Consumer Credit Act procedure, but they have the same requirements. For a credit agreement to be enforceable, the creditor has, or the debt purchaser has to be able to show they've complied. Lowell's Group, for example, issues hundreds of thousands of claims a year on the online system getting default judgments. If the ones that are being defended by litigants in person are going to be on this, put on this new system, then surely the relevant direction questionnaires, etc., should ask, is this a Consumer Credit Act claim? And then at least the judge knows it. Often the particular claim don't even plead they're regulated by the Consumer Credit Act.
I think it's a technical point you're dealing with, and I think you need to probably write to me with that point and we'll look at it. I'm sure you're right, there's something there, but I think I was dealing with the general.
I accept that, sir.
Yeah.
The gentleman at the back. Gentleman at the back.
Hi, Barry Matthews. I'm a FTSE 100 GC and founder of the Social Mobility Business Partnership, which is a charity that brings together 160 general counsel across the UK to provide work experience and lifetime career coaching. I'm really interested in the points you made, and thank you for your great work in this space, around mandatory training on diversity for the profession. Where do you see the role of the regulator starts and finishes, and the role of the representative body then takes over the baton?
I would be trespassing on an area that I don't fully understand if I said everything should be made compulsory. I think I would like to see everybody in the legal sector trained in diversity and inclusion and equality because, as I say, my own personal experience is that there is no substitute for face-to-face training and understanding the issues, confronting them from your own perspective. It doesn't matter who you are, you can do better. And you only address those problems if somebody says, do you know how you behave in a particular situation? You could behave better. So I think training is absolutely invaluable. As for compulsion, you know, as I say, bring everybody with you. I think you have to explain to people why it is so important for them to understand this question. It was said by Helen, I think, and maybe by you as well, that diversity is not just for the sake of it. It's not for some principle. It is because it is better for our society if we include everybody. Legal services are better if they come from a diverse selection of people with an understanding of the problems. When I chaired the Social Mobility Foundation, I always explained that you're not wanting social mobility so that for some sort of ethereal principle. You want social mobility because you want to be able to see difficult legal problems through different ends of the telescope. And if you achieve that, you'll give better advice, you'll have better outcomes, the legal advice will be better, and indeed judicial resolutions will be better, which is why we need a diverse judiciary.